Welcome to the Deep Dive. We're here to really make sense of the news that matters. We take a close look at key sources so you can get those crucial insights, without all the noise.
Exactly. Cutting through to what's important.
And today, our focus is definitely on something significant. It's a major legal development from the UK, the Supreme Court's judgment for Women Scotland Ltd versus the Scottish ministers. This came down on April 16th, 2025.
A big one.
It really feels like it. This ruling could genuinely reshape how we understand equality law in the UK. So we're going to unpack what it might mean for the future, thinking about everyday services, the wider legal stuff, and maybe even how it might ripple out to other places.
Yeah, we're looking beyond just the legal text here. It's about the practical real-world changes this ruling is likely to kickstart. It gives us a new lens for the Equality Act.
Okay, so let's dive right in. The core issue, the big question for the court, was about the meaning of sex, man and woman, in the Equality Act 2010.
That's right.
Specifically, did those terms include people who've got a Gender Recognition Certificate, a GRC, under the 2004 Act? What did the UK's highest court actually say?
Well, they were pretty clear, actually. The Supreme Court ruled that for the Equality Act 2010, sex, woman, and man mean biological sex. The sex assigned at birth.
Not the certificated sex from a GRC.
No. Not for the purposes of this act. So the key insight is really this legal reset, isn't it? It anchors sex in equality law back to biology. It creates a clearer framework, though. It probably raises some new questions, too.
Right. So just to be totally clear, if someone has a GRC confirming their gender identity, say a trans woman, how is she viewed under the Equality Act now, specifically for sex discrimination?
For the purpose of sex discrimination claims under the EA 2010, a trans woman with a GRC is legally considered male, because her biological sex is male.
And the reverse for a trans man.
And conversely, yes, a trans man with a GRC is considered female under the EA 2010 for those purposes, because his biological sex is female.
Wow. That's a really significant clarification. It sounds like it directly challenges that for all purposes idea in the Gender Recognition Act, doesn't it?
It does seem that way on the surface. Section 9 of the GRA 2004 does say a person's gender becomes their acquired gender for all purposes when they get a full GRC.
Right.
But the Supreme Court pointed straight to Section 9.3 of the same act. And that subsection says the for all purposes rule is subject to provisions made in other laws.
Wow.
And their interpretation is that the Equality Act 2010 contains such provisions. It essentially carves out specific exceptions within equality law. So think of the GRA as the general rule, but the EA 2010 says, hold on, for these specific equality situations, we need a different approach based on biological sex.
Got it. So the Equality Act takes precedence here for its own definitions. Okay, with that foundation, sex means biological sex in the EA 2010. Let's talk practical changes. What about single-sex and separate-sex services? Big area.
Huge. Yeah, this is probably where you'll see the most immediate effects in daily life.
Like toilets, changing rooms, maybe shelters.
Exactly, those kinds of things. The judgment clarifies that service providers offering services for just one sex can now legally base access on biological sex.
Without it automatically being sex discrimination.
Correct. So a women's only toilet or a men's changing room can restrict access to biological females or biological males, respectively, without that automatically being unlawful sex discrimination under the Act. Schedule 3 of the Act already had exceptions, This ruling basically says those exceptions can be applied using biological sex as the criterion. It gives a much clearer legal basis.
So let's take an example, a women's refuge. They could now, with clearer legal backing, say they only admit biological women if they feel it's necessary for safety.
Precisely. The ruling supports that idea, that the exceptions in Schedule 3 were meant to allow services specifically for biological women or men where it's appropriate. And yes, that could mean excluding someone with the protected characteristic of gender reassignment, even if they have a GRC. The court actually mentioned various scenarios, shelters, yes, but also things like communal showers, maybe even some healthcare settings. The big change is that providers now have biological sex as a clearer justification for access rules.
Right, that makes sense for services. What about associations, clubs or groups set up for single sex, women's groups, men's clubs, that sort of thing? How does this affect who they can have as members?
Yeah, good question. Part 7 and Schedule 16 of the Act cover associations, and the ruling brings clarity here too.
How so?
Well, single-sex associations, the Act, defines them, at least 25 members. Selective entry, they can now restrict membership based on biological sex without it being sex discrimination.
So groups specifically for biological women can state that in its rules now.
Yes. They can explicitly define their membership criteria based on biological sex, and that aligns with the Supreme Court's interpretation of sex in the EA 2010. It reinforces their ability to be, genuinely single-sex based on biology.
So it supports the idea that these groups can maintain that specific character.
Exactly. The court reasoned that if sex meant certificated sex, then the exceptions allowing single-sex associations wouldn't really work as intended. You couldn't guarantee, say, an association composed only of biological women. This interpretation makes it more straightforward for them.
Okay. Another area where this feels like it will have a big and perhaps quite visible impact is sports, competitive sports. How does clarifying sex change the rules about who competes in men's versus women's categories?
Right. Section 195 of the Equality Act deals with sport, specifically what it calls gender-affected activities.
Meaning where biology gives one sex an advantage.
Precisely. Where physical strength, stamina, or physique are major factors. The Supreme Court's ruling makes it much clearer now that sports organizations can exclude biological males, and that includes trans women, regardless of GRC status from women's competitions.
On what grounds?
To ensure fair competition or for safety. This relies on the specific sex discrimination exception in Section 195 of the Act. It gives governing bodies a clearer legal basis if they decide separate categories based on biological sex are necessary.
That's quite a shift. What about the other way around? Trans men competing in men's sports?
Well, the ruling touches on that indirectly. Section 195(1) is about excluding biological males from female competition. But Section 195 provides a different exception based on gender reassignment.
Okay.
This allows organizers to exclude any trans person, trans woman, or trans man, GRC or not, if it's necessary for fair competition or safety. So, theoretically, if a body felt a trans man had an unfair advantage or disadvantage affecting fairness or safety in men's sport, they could potentially use that subsection. It's a separate consideration from the main sex definition ruling.
Interesting distinction. Okay, let's shift gears a bit. What about employment-related issues, like pregnancy and maternity rights?
Yeah.
How does the ruling play out there?
This is actually an area where the biological definition resolves potential problems.
How so?
Well, imagine if woman legally included a biological male with a GRC, then protections specifically designed around the biological reality of pregnancy and childbirth could become messy.
Ah, I see.
The ruling clarifies that because woman in the Equality Act always means biological female, the protections for pregnancy and maternity automatically apply to biological women. It doesn't matter if they hold a GRC, making them legally male for other purposes.
So a trans man who is biologically female and could become pregnant retains those protections.
Exactly. It avoids that potential gap where a trans man might have lost access to vital maternity rights and pay protections listed in the Act, like in Schedule 7 and 9, just because of his GRC status. It keeps those protections tied to biological capability.
Okay. And what about sexual orientation? Does the ruling affect how we understand being gay, lesbian, or straight under the Act?
It mostly just reinforces the existing understanding, really. Section 12 defines sexual orientation based on attraction to a specific sex. If sex meant certificated sex, things could get complicated, right? You could have a biological male with a GRC identifying as female, attracted to females, legally lesbian. It becomes quite circular.
Yeah, okay.
By confirming sex means biological sex, the ruling keeps the definition of sexual orientation anchored to attraction based on biology, which is much more straightforward.
Right. Now, public bodies have this thing called the Public Sector Equality Duty, the PSED. How does this biological sex definition affect their duties regarding sex equality?
It gives them a clearer framework, essentially. Part of the PSED is about eliminating sex discrimination and advancing equality for women.
So they can now focus that on biological women more clearly.
Yes. If they're implementing positive action measures, for instance, to increase women's participation in a certain field, they can now clearly target biological women as the defined group under the sex characteristic.
But what about trans people?
Crucially, their needs are still covered. They have protections under the separate characteristic of gender reassignment. So public bodies still have a duty to consider trans people's needs and eliminate discrimination against them under that heading. It just separates the considerations more clearly.
Okay, that's an important distinction. This ruling is UK-specific, obviously. But you mentioned potential ripples elsewhere. What kind of impact might it have in other, say, common law countries with similar laws.
Well, it's not binding, of course, but a judgment from the UK Supreme Court carries significant weight internationally, particularly in other common law systems like Canada, Australia, and New Zealand.
So they might look at it.
They very well might. If courts or legislators in those countries are wrestling with similar questions about defining sex in their own equality laws, this UK judgment provides a detailed, high-level piece of reasoning they can consider. It could definitely influence legal debates and maybe even future court decisions or legislative reviews elsewhere. It adds a significant voice to the global conversation.
Okay. Now, it feels really important to also state clearly what this ruling doesn't do, especially regarding protections for trans people.
Absolutely vital. The Supreme Court was explicit about this. This judgment does not remove protections for trans individuals under the Equality Act 2010.
So they are still protected.
Yes. Discrimination and harassment based on the protected characteristic of gender reassignment are still unlawful. That hasn't changed.
And the court mentioned something else, too.
Yes. They also noted that trans people can still bring claims for direct sex discrimination if they are treated unfairly because they are perceived as being the sex they identify with. So if a trans woman is discriminated against as a woman, she could potentially still bring a sex discrimination claim on that basis. The ruling clarifies the definition for establishing comparison groups, but doesn't remove avenues for seeking justice.
Understood. Finally, what about the Equality and Human Rights Commission, the EHRC? They're the body responsible for enforcing this act, right? What's their take been?
Well, their position has evolved a bit. Initially, their interpretations might have differed, but more recently, the EHRC has publicly acknowledged the practical difficulties and ambiguities that arise if sex in the act is read to mean certificated sex in all contexts.
It's the kinds of difficulties we've been discussing.
Exactly. For things like services, sports, associations. They've actually gone so far as to suggest that Parliament might need to amend the Equality Act to provide absolute clarity, potentially by explicitly defining sex as biological sex within the legislation itself.
So the court's ruling aligns somewhat with the direction the EHRC was already indicating.
It seems to address the very practical problems that EHRC had highlighted, yes. The court certainly took note of the Commission's views on those difficulties.
Okay, this has been incredibly helpful in breaking down a really complex and very significant ruling. So just to quickly recap the main takeaway, the UK Supreme Court says sex in the Equality Act 2010 means biological sex.
That's the core finding.
And this has potentially major knock-on effects for single-sex services, clubs, sports, even pregnancy rights. It aims for clarity in applying anti-discrimination law.
Well, crucially, keeping the separate protections based on gender reassignment firmly in place for transgender people.
Right. And it's a decision that could well echo in legal discussions in other countries facing similar questions.
Definitely one to watch internationally. The focus now really shifts to implementation. How will organizations adapt? What happens next?
Exactly. And that leads us perfectly into our final thought for you, the listener. Now that we have this clear legal definition of sex within UK equality law, how might we actually see services, organizations, maybe even employers adapt their rules and practices on the ground? What are the real-world implications going to be as this filters through society? And how do we continue to balance fairness, safety, inclusion, and the rights of everyone involved?
Lots to think about there.
Definitely. We really encourage you to maybe look at the full judgment summary or follow the ongoing discussions around this. Thanks for joining us on the Deep Dive.